the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Hello, everyone, and welcome to the Fair Housing Insiders Case Files, episode 27 with Leslie Tucker, the principal of Williams, Edelstein, and Tucker. I am your host, Jonathan Sarr. So today we're talking about United States versus MSM Brothers. So Leslie, have you had a chance to review that case yet?
I have, Jonathan. Yeah, it's an interesting case when it comes to understanding familial status protections under the Fair Housing Act. Where do you want to start?
I thought it would be good to talk about the basics. This case was filed by the Department of Justice on behalf of Kelsey Hoyne against MSM Brothers Incorporated and its operations manager. The complaint alleges discriminatory housing practices at a residential property in New Hampshire.
Yes, that is right. So the core issue was that the management company at this particular property was alleged to have maintained a policy or practice that any families with young children, in this case, children under the age of 10, had to be placed on the first floor, even if second or third floor units were available. So any families with children who were applying were very limited in their options.
That's very interesting. I think anyone who has lived below a household with young children can understand the reasoning behind that policy. There's a much larger chance of the neighbors hearing typical stuff that kids do, jumping, running, crying, other noises. I know what it's like when I have 3 of my grandchildren in the house, so I can totally understand what all of that noise is like. But because familial status is a protected category under the Fair Housing Act, limiting these households' options is illegal.
Exactly. And I can certainly relate to that, your experience too, with my young children. But what this practice would constitute is illegal steering, which is when a landlord directs applicants to certain units or areas of a community based on their protected category. But not just steering, it also constitutes just very basic discrimination. In this case, the applicant inquired about available 2-bedroom units. When she informed management that she'd be residing with her infant, she was informed, allegedly, that only first floor units were available for families with children, and there were no first floor units available at that time. So she essentially wasn't able to be housed because of the fact that she was going to be living with her infant, and she was told to call back in the future.
Okay. So just for clarification for our audience, so she wasn't able to rent a unit on the first floor at that time, but were there other units that she could have been approved for?
Yes. The government's case says yes. The investigation revealed that at the time of her visit, there were available units on the second and third floors, but she allegedly was not permitted to apply for those units because, she had a young child. In fact, she even indicated that she would have preferred to live on an upper floor.
Okay. So how did the government not know that this was just a fluke? Couldn't this have been an employee that didn't know the correct policy?
Good question. And the answer is no. They did find out that it was not just a fluke. After the complainant's visit, the applicant contacted the New Hampshire Legal Assistance Fair Housing Project for assistance. And this agency, upon finding out what she, was alleging here, they started conducting tests. And their testing confirmed that this was in fact the property's policy or practice regarding families with young children. In other words, it didn't just happen once, it kind of came up over and over again. Testing is a very common practice when an agency gets involved and learns that there may be potential illegal practices going on at properties. And it's just their way of collecting evidence against a housing provider for a later complaint. So after this testing was done, a HUD complaint was filed, and HUD did find cause to believe that a violation had occurred, and then this lawsuit resulted.
Got it. Okay. So what was the outcome? Did the parties end up settling the case?
Yes. Yeah, the parties did settle. The housing provider ended up paying $25,000 to the plaintiff. And they agreed to, train, change their policies, and of course, provide annual reports to the Department of Justice. This case really does serve as a good reminder that some policies, they may seem harmless, they may seem well-intentioned, like trying to reduce noise for a downstairs neighbor, but it can still certainly be discriminatory and illegal. And of course, as we see, the consequences for that can be severe.
Yes. I guess like the old expression, an ounce of prevention is worth a pound of cure. Well, if that's the right one. So prevention, don't get into that situation. Don't go down that road. Training, be trained. Yeah. Good reminders for our audience. So appreciate the insightful discussion, Leslie. Wonderful. That wraps up our discussion on United States versus MSM Brothers Incorporated. Critical case that underscores the importance of being aware and upholding fair housing practices. So thank you to our community. Thank you for tuning in to this episode. We look forward to next time. Take care, everyone.